case briefs, and so much more. LSData's got what you're looking for.
In a 1982 legal tussle involving the prestigious Penthouse magazine, First Amendment protections came head-to-head with allegations of defamation. At the epicenter of the lawsuit was a Miss Wyoming contestant, who set legal wheels in motion after an article published in the magazine seemingly cast her in a false light. The contestant from the Miss America Pageant argued that the Penthouse article insinuated she had performed sexual acts during the contest, an allegation she furiously denied. Taking legal action, she claimed that the publication had defamed her through these implied fabrications. Initially, the trial court sided with the contestant, failing to consider the reasonably understood principle and treating the story as a definitive statement of fact. The court then realized this critical misstep. It reconsidered whether the contentious article was truly about the plaintiff, and moreover, whether it could be reasonably construed as depicting actual events involving her. Key to this U-turn was the notion that the classification of a story as fiction or humor is moot in deciding if it can be construed as factual. Following this line of thought, the court determined that the contested parts of the story were indeed fantastical, and therefore not a statement of fact about the plaintiff. The Court of Appeals echoed this decision. Upholding the rights of the magazine, it deemed parts of the story as pure fantasy, thereby falling under the protection of the First Amendment. The Supreme Court's precedent affirmed this stance, ruling that even vulgar magazines are protected under the First Amendment. In the final stroke of the judicial pen, the court reversed the earlier judgment, dismissed the case, and set aside the jury verdict. This ruling drove home the point that the First Amendment protects all viewpoints and ideas, regardless of their conformity with community standards. A sobering reminder of the power and reach of the First Amendment, the Pring v. Penthouse International limited case serves as a staunch deterrent against unduly restricting literary creativity.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class